importance of their oath. And I think that that's also recognized very strongly in this court's case law and case law of other jurisdictions, and that this court has expressed that jurors are presumed to take that oath very seriously, that they're presumed to be people of ordinary firmness, that they are not presumed to blow with the winds of every opinion that swirls around them. And so I think that's an important place to start when we look at this particular case. And when we look at this particular case, what we are talking about is what Justice Toll described as a few fleeting comments. And in the face of that, we have to consider a 6-week trial with almost 90 witnesses, with almost 600 exhibits, with Judge Newman, with the entire prosecution team, with the entire defense team, and all of that presentation over 6 weeks. And to get there and to do what ultimately is the analysis is we have to assume that at some point prior to deliberation, during the presentation of evidence, with all of that going on, some jurors like, well, you know, I didn't know what I was going to do, but Miss Becky said, you know, watch his body language, and that made the difference. And I would submit to you that that is simply not a finding that is justified in this evidence. It's not a finding that's justified under what we know about jurors, and it's not a finding that's justified by what the jurors said in this particular case. Now, to sort of detail my my analysis in my free 5 minutes that I have here before the questioning comes, is we have 606, and we've got two issues. We've got number one is what happened. And then we've got number two, which is how do we analyze that particular issue? And when we start with what happened, that is obviously a credibility and fact-finding effort by the trial court. This court is very clear that the trial court, because this is not like a trial, this is a procedure that is in the discretion of the trial court, and ultimately any credibility findings, fact findings, this court respectfully would defer to. And so to determine that, what exactly happened? And this court ultimately credited the 11 jurors. And so what do we have with those 11 jurors? We have one juror saying that Ms. Hill said this is an epic day and the defendant is going to testify, all right? And then we have another juror who says watch his body language. And beyond that, the court clearly did not credit Juror Z, and I'll get into more about that, but there's plenty of the support in the record why the court could not credit what Juror Z said. Juror Z was ambivalent. Her answers were all over the place. None of the other jurors heard all those egregious statements. She couldn't even remember all of these egregious statements when she was on the stand. She said, I don't remember them. All of these things that really would take this analysis into a different level, she didn't remember. So when we boil it down to what happened, we're talking about epic day. All right, epic day, everybody in the courtroom knew it was an epic day. That is not news to anyone. Everybody knew it was an epic day. It is rare for a defendant to testify. That on its face is a neutral comment. That is not necessarily a comment one way or the other. And if anything, we've seen where instances of a jury in deliberation considering the fact that a defendant didn't testify, saying, you know, he must be guilty because he didn't testify, that's actually been an inference that goes more in favor of the defendant than against him, the fact that he's testifying. But again, it's rare that a defendant will testify. That ultimately is a neutral statement as well. And then watch his body language. Again, that is what was found, not don't get fooled by his comments or anything like that. That was not what was found by the trial court, just a neutral comment of watch his body language. And so that is the facts, the three facts that we have to ultimately assess. So when we move on from there, then the analysis is how do we analyze that? And first of all, we have the discussion of whether or not there's a presumption of prejudice. Justice Toll, of course, found, based on this court's clear case law, that there was not. But I would agree, I would submit to you that not only because of the alternative findings, but just because of a general analysis that regardless of who had the burden, that presumption of prejudice was overcome in this particular case. And I'll talk more about that in a second. But I think ultimately the legal analysis, whichever way you go, I don't think is going to be dispositive because of the relatively non-egregious nature of these comments. They are nothing like the comments that were in the cases that have led to reversal. So let's talk a little bit about more of the findings that were there. In looking at the evidentiary hearing that was done, we had, of course, Ms. Hill testify, and the judge found that she was not completely credible. We had Ms. Rhonda testify. The court did not credit that testimony because Ms. Rhonda conceded over and over again that she absolutely heard nothing whatsoever of any.
Mr. Waters,
Yes,
I
ma'am.
want to stop you right there,
Yep.
since your 5 minutes is up, and talk a little bit more about Juror Z.
Yes, ma'am.
You're saying these are innocuous comments, not to be fooled, and look at his actions, look at his movements. The court seems to believe Juror Z when she says in her affidavit and when she testifies that these comments were made to her. However, she goes on in her affidavit to say, not to be fooled, which I understood to mean Mr. Murdaugh would lie when he testified. Look at his actions, look at his movements, which I understood to mean that he was guilty. The juror is testifying in her affidavit that the effect on her was significant. How can the court find that certain comments that she made, take them and incorporate them in the order, but not believe what she says about the effect?
Well, two things about that. I think that, first of all, Justice Toll did not credit any of the egregious comments that she didn't even remember herself on the stand, such as "won't get fooled." The only comment that was credited was what was testified by Juror P, which is "watch his body language."
And let me, and I want you to finish your answer, but I want to ask you this. So far as the comments are concerned, are we limited, is this court limited to only the comments that are included in Judge Toll's order? Or are we able to consider all the comments that are included in the affidavits, even the egg juror affidavit?
Well, what I would say to that is the case law is clear that the trial court has the discretion to conduct this hearing and ultimately make credibility findings, which under typical appellate law, this court would defer to. And so my argument to that is if you look at Justice Toll's order, both her oral order and her written order, she credited the 11 and did not credit Juror Z and did not give any credence to 741, the alternate, and or the egg lady, which of course did not testify. Now there was on page 808 of the record where she says, I think we've got in terms of what she says, Ms. Hill says, and what Ms. Hill says she says. That's on page 808 of the record and talking about the egg lady juror. But ultimately, I would submit that this court in appellate review does need to defer to credibility and factual findings of the trial court. And the trial court only found the 11 credible. And
well, then help us understand the ostensible inconsistency when the trial court finds portions of Juror Z's affidavit credible and just carves out and doesn't deal with the part that dovetails with the alternate juror's testimony, which is far more prejudicial.
Sure.
How do we do that?
Well, so we're looking for, I would submit from an appellate court's standard of review, we're looking for support in the record for those findings. And so when you look at Juror Z, okay, and first of all, you look at the 11, which she did credit, and none of those 11 heard any of these other egregious comments or anything like that. None of
What
them
do we do about the order that doesn't even mention that Juror Z did in fact testify about the comment, "Don't let the defense confuse you"?
Well, I think that when you look at the order in her specific paragraph on Juror Z, what she says is that Juror Z was ambivalent, and ultimately, as she goes through the analysis of what Juror Z says, she's not crediting that testimony. And again, I think there's support in the record for that.
There may be, and that may carry the day for you.
Right.
Assume that we find that that statement was made. Do you still have a path to victory?
That don't be fooled?
At the end of the state's case, before the defense presents its case, the statement was made, "Do not be confused. Do not be misled by defense and its counsel."
Right. Well, I would say, and this is like everything in this, it is a question of degree, okay? And there could, if the clerk had come in there and held a gun to their heads and said, you better vote guilty or I'm going to shoot you all, I probably wouldn't even be arguing that's not structural error, okay? But everything is a question of degree. I'm not going to concede that if those statements were credited and are part of the review, that our path to victory is not harder. But I think you have to look at that in the context of this entire trial and when those particular statements were made.
Right, and I think context is important too. We all can cherry pick some of these that are on the surface innocuous. Epic day, big day, and when viewed in isolation, they don't move the needle, arguably. But when those seemingly innocuous statements are considered in the aftermath of the originating statement, not to be confused and misled by the defense, those initial innocuous statements take on a very nefarious message.
I could not argue otherwise, that it would absolutely be a question of degree. However, I don't believe that that just ends the inquiry right there, because you still have to analyze it in the context of all of the factors and everything that went on. And so to look at that, let's look at all of the things, and let's assume that we're limiting it to what I contend Justice Toll found, which again, when I say innocuous, I'm saying relatively not egregious. I'm not saying that the clerk should be saying watch his body language, okay? But that is a far different comment from what you're talking about right there. But
Yes,
even
sir.
if we add that in, we're still talking about a limited, number of jurors who saw that. And then we're putting that in the context of where that occurred, okay? It occurred during the middle of the defense case, not during deliberations, not right before deliberations, but in the middle of the defense case. It occurred during, I think we counted no less than 60 times that this jury was told by Judge Newman to only, rely on the evidence, to not talk about the case, to not have external influence and all the rest of that. And we have to credit that. We also have to, again, put that in the context that when and if that occurred, and even assuming that there was a one bit beyond that it was attenuated from the actual point of deliberation by the rest of the defense case, by the entirety of the state's reply case, by all of the closing arguments of counsel, and by Judge Newman's very detailed charge. And so while that would be different, I don't think that that is fatal when you look at the entirety of this 6-week trial. And again, go back to what I said ultimately at the beginning of my argument here is that for that to happen, you'd have to conclude that with all of that going on, with this massive evidentiary presentation, with multiple instructions from the trial judge, with all of these arguments of counsel.
So you're distinguishing a day-and-a-half-long burglary third trial from this trial?
No, sir, but what I am saying is that I do think time matters. I do think.
But you would agree that at the end of a Berg third trial with a guilty verdict, the judge finds out that the clerk of court was back in the jury room saying something like, well, that defendant's not going to testify. But I just want to let you know, this is the 5th time he's been up here for a burglary third. So I just want you to know that. Egregious or not?
Your Honor, if that were the case, I would be very hard-pressed to argue otherwise.
Okay, so help me out with this. If we craft a standard based on the length of a trial, and heavens know, nobody wants to try this case again, how do we create a standard based on a lengthy trial versus a day-long trial when the constitutional right is the same?
Absolutely, the constitutional right is the same. And what I'm not asking is this court craft a different standard for a long trial versus a short trial. What I am saying is what is relevant to the ultimate inquiry that this court engages in is the timing of when these comments took place.
Okay, well, let's talk about that, and I'll weave in some questions about the egg juror. Ms. McElveen, the Barnwell County Clerk of Court, said she didn't hear any of these comments made in front of jurors, but the comments made to Ms. McElveen by Ms. Hill were remarkably the same as those related by the jurors. For example, watch him closely, look at his actions, look at his movements. Ms. Hill was saying that to staff and to Ms. McElveen. You agree that's what she testified, correct?
That's what she testified to.
That does match almost exactly what these jurors said Ms. Hill told them, correct?
It is.
Okay, so explain to me how we pass go under your theory. How do we accept the fact that Judge Toll maybe didn't mention all these things in her order, but they were supported by an impartial witness, that being the clerk of court from Barnwell?
Well, two things about that. I don't think we can get past what you've recognized, that clerk of court from Barnwell heard nothing going to a juror, or she would have brought that to the court's attention.
But the consistency of the comments or the similar nature of the comments is striking.
Well, and then my second part that I would say about this is that all of this arose months and months and months after trial. And the courts have been, historically reluctant because of that passage in time, because of the fact that jurors vote one day and one day only, and don't have to assent to their verdict and vote him guilty every single day for the rest of their lives. And so I think that passage of time is something that is relevant as well when this case is being talked about incessantly out in the world. And so I think that's something as well that Justice Toll can consider in deciding what actually happened. And the best evidence of what actually happened, and whether or not it is, whether you look at what the jurors said about it, not to get to the 606 aspect of it, or if you're objectively standing back and making that factual finding of this is what happened and this is whether or not there's a prejudicial effect, that is why Justice Toll credited those 11 jurors, and that is, I would submit to you, the realm of what this court needs to consider.
I want to ask you a question about this idea that you expressed, that this event or these moments when the clerk spoke to the jurors should be considered insignificant when viewed among the entire trial, whether it's a long or short trial. There's no eyewitness, there's no DNA, there's no one thing on the part of the state that you could rely on to show him guilty. So you had to piece together a whole bunch of different stuff. We'll talk about a lot of that stuff in the next phase. But
Yes.
But you spent, most of that 6 weeks was you piecing together small pieces of evidence to put together an argument that he did it. Mm-hmm. On his side, now of course he doesn't have the burden and isn't even required to testify, but on his side, whether he's guilty or innocent boils down to one moment, one thing, and that's when Alex sat up on the stand and said, "I didn't do it." Mm-hmm. So what I'm wondering is, you're wanting us to consider the statements by the clerk to be insignificant, but those statements go to the only thing that the defendant really had. I mean, the defendant can argue that you didn't piece it all together, but really the defendant's argument boils down to the one thing that the clerk of court addressed. So we can look at all this context if you want to, but the jurors knew that if Alex was telling the truth, he's not guilty. If he's lying, he is guilty. And that's where the clerk of court's statements appear to focus. How do you respond to that?
Well, I would say that while I understand that obviously was very important, the defendant taking the stand, it wasn't as simple as just getting up there and saying, "I didn't do it," okay? And while there was a long piecing together of all of that, the defendant's testimony was also very long over the course of 2 days. And so I don't think that you can just view the defendant's testimony entirely in isolation of this entire trial. I don't think any analysis has ever said that we're going to ignore the entirety of what went on.